Good morning to all of you.
Morning, Your Honor.
Court will note the appearance of Ms. Moss and Ms. Reynolds on behalf of the plaintiff, defending appearing in pro per. On behalf of plaintiff, who's going to be arguing that?
I will, Your Honor. Megan Reynolds.
Okay. The plaintiff has filed a motion to revoke acknowledgement of paternity in this particular matter. Ms. Reynolds, have you seen the defendant's response?
I have. I received it on Friday.
Okay, go ahead, Ms.
Your Honor,
Reynolds.
and I will address his response briefly in my comments. I did brief this. I won't belabor it, but I will summarize partially for the defendant's benefit the law. As our motion and brief summarize, both the Child Custody Act and the Revocation of Paternity Act contain protections for mothers like my client who choose to carry a child after they learn they are pregnant following criminal conduct. The Child Custody Act states that the court shall not, it's not permissive, shall not grant custody or parenting time to the offending parent. In this case, the offending parent is the defendant. He was convicted of multiple CSEs against the plaintiff when she was an underage high school student, and he was a teacher in her school. He remains in prison for those offenses at this time, but that hasn't stopped him from filing a motion asserting that he is entitled to parenting time with the child while he remains in prison and for the child to remain available to him while he's in prison. The Revocation of Paternity Act also provides that a mother may file an action to block the offender from establishing paternity, or they may revoke paternity if it was already established. In this case, the plaintiff is asking to revoke the affidavit of parentage that she signed shortly after the child was born. My understanding is that law enforcement officials brought the AOP to defendant to sign in jail because he was already in pretrial detention at the time the child was born. The Calhoun County Prosecuting Attorney's Office filed this support action for child support and birth expenses. Unsurprisingly, as a teenager who'd been victimized by an adult and left pregnant, Ms. Blackman had to rely on Medicaid to cover the cost of the child's birth. When Mr. Millward answered the complaint for support that had been filed by the prosecutor, he requested custody and parenting time. It was left to Ms. Blackman to represent herself on those issues, and at the time, she was not aware of her statutory rights as a survivor of CSE. Ms. Blackman was granted sole legal and sole physical of the custody of the child, but the 2019 order left open the possibility that defendant could seek parenting time at a later date. That was an error. MCL 722-27A4 states that the court shall not grant parenting time to the offending parent. Ms. Blackman, however, did not waive her rights under the statute when that order entered in 2019. In fact, she cannot waive the protections except under the one very narrow exception that's defined in the statute. And that is if she had cohabitated with the offender after the child was born and raised the child with him, creating an established custodial environment for both parents. And that didn't happen. Mr. Millward has been in jail or prison since this child was born. He admitted in his response as much, and he therefore does not have an ECE with this child. For that reason, we ask that Your Honor immediately grant plaintiff's motion to dismiss defendant's motion for parenting time that's pending. And there is an evidentiary hearing that's pending on that we would like to have canceled and are requesting to have canceled when the motion is dismissed, and that you immediately enter an order revoking his paternity. The defendant's response that I received on Friday would ask this court to hold an evidentiary hearing regarding when the child was conceived and or whether the plaintiff waived the protections for survivors of criminal conduct. That request should be denied. A fact-finding hearing is not called for in this case. Both the CCA and ROPA allow for a fact-finding hearing in certain scenarios where there has not been a criminal conduct conviction. So if there'd never been a conviction, but only an allegation that there had been a CSC, then a mother could raise that allegation and ask for an evidentiary hearing for this purpose. But this case doesn't require an evidentiary hearing because Your Honor can take judicial notice that defendant was convicted of CSC against my client, not just in Calhoun County, but also additional counts in Branch County and St. Joseph County, all against Ms. Blackman. The defendant's response appears to rest on when he stopped being employed by plaintiff's school. It should be noted that he resigned once his conduct towards Ms. Blackman started to be investigated by law enforcement. It should also be noted that he picked up additional convictions for witness intimidation against my client by trying to stop her from cooperating with police. But Your Honor, this is not a criminal matter and this court sits in equity. MCL 722-26-1, part of the Child Custody Act, makes clear that the Child Custody Act is equitable in nature and shall be liberally construed. Defendant's attempt to narrow the question of timing of conception is a distraction from this court's duty to interpret the CCA in an equitable manner. The purpose of the provisions for rape victims who carry their offender's child is to protect them from additional psychological trauma and to allow the child to be raised in a healthy environment without the interference of the offender. Furthermore, the crime of CSC by a teacher against a student has been found by our Court of Appeals to apply to offenses outside of a strict school calendar of employment. And People v. Lewis, 302 Mich. App 338, which I can provide to this court a copy of, given the late filing of defendant's response, the Court of Appeals found that a longtime substitute teacher's session of a former student during the summer after he had been her teacher was a CSC under the same statute that the defendant was convicted of. The Lewis court found that more important than the timing of the offense was the occupation of the actor and the vulnerability of the student, and that wasn't changed by the fact that it was summer. People v. Lewis has not been overturned. It remains good law. There has been subsequent cases of CSC in the criminal context parsing how long after the defendant ceased being the teacher of the student that there might no longer be a conviction under the statute. But again, the CCA is equitable, and so that issue is not dispositive of his parental rights under the Child Custody Act. He might have found a strict statutory reading in his criminal matter about that timeline, but under the CCA and ROPA, the only way a victim of a CCA who becomes pregnant with the assailant's child may waive the protection is that very narrow one that I mentioned, that if she went on to cohabit and live and raise the child with him, and there's no evidence and proof, and there's an admission that those facts do not fit in this case. As we explained in our brief, there's no published case law related to these statutory protections. However, the statutory language is very straightforward, and in the only known case that's been reported in the media of a Michigan court granting paternity, custody, or parenting time to a convicted CSC offender since the passage of these statutes occurred in Sanilac County in 2018. And in that high-profile case, the judge vacated the orders, and the prosecutor publicly apologized for the filing of the support case as soon as they realized they'd overlooked the offending parent's CSC conviction against the mother, who, like my client, was also a teenage victim. Your Honor, we ask that you do the same. The orders in this case should never have entered, and they must be corrected by entering an order now, revoking defendant's paternity and shutting the door that was left open for him to seek parenting time. Thank you.
Thank you. Mr. Millward, what's your response?
Yeah, I'd first like to say what happened back in 2018. I have empathy for the victim. I regret all my decisions, all my
Okay,
actions.
sir, I don't need to know that. I need to know what's your response to the motion.
Yeah, so based on my understanding, Ms. Reynolds is right. If the child was conceived when I was a teacher before February 12th of 2018, then these laws would apply. I would never be able to get parenting time with Elijah, our son. However, Elijah was conceived in the middle of March of 2018. That was a month after I resigned as a teacher from Athens area schools. And in Exhibit A, I have that resignation letter from the superintendent that made my last official day, February 12th. So after that, Shannon and I decided to continue our relationship. After I resigned, she was of legal age. The relationship was mutual and consensual. And her and I both agreed that Elijah was conceived on St. Patrick's Day weekend of March 2018. So I don't see how this Revocation of Parentage Act applies to this situation unless he was conceived when I was still a teacher. The second part of the argument is that the plaintiff was under duress when she signed the affidavit of parentage. Now, our son was born in the middle of December of 2018, December 14th. I went to jail a month before that, November 14th of 2018. As soon as I went to jail, the attorneys, the detectives, they all made it very clear to me and my entire family. Absolutely no contact with Shannon or her family. We followed that. I remember the affidavit of parentage was brought to me when I was in jail by a jail lieutenant, and I signed it. And she had already signed it when I had received it. And if this were to go to the evidentiary hearing, I would have family members be able to testify that nobody communicated with Shannon to put her under duress, at least from my side of the family, to sign that affidavit of parentage. There are two main reasons I filed this motion back in March. The first is because parenting time was reserved at the end of 2019. And it stated that the parenting time section stated that my parenting time be reserved until the child attains a more appropriate age to deal with parenting time in prison. It was also around this time at the end of 2019 where Shannon reached out to my mother and asked if my mother could start watching our son on a weekly basis. Now, starting at the end of 2019, I started talking to my son on the phone on average, once per week when my mother had him, usually on the weekends. This lasted all the way up to the beginning of 2023. I attached an exhibit B, which proves that Shannon knew about this communication between me and our son, and she was actually excited that it was happening. Also, I attached exhibits C, D, E, C, D, and E, which show that my mother had temporary custody and power of attorney of Elijah for 6 months in the year 2022, specifically between April and October of 2022. Now, based on my understanding, because I haven't talked to Shannon in a while, and I can't contact her through the no contact order. From what I've heard, she actually she begged my mom for a couple weeks to take custody of Elijah temporarily because she was going through a very difficult time mentally. And emotionally, she had an abortion as a result of a abusive relationship with a boyfriend. Maybe not physically abusive, but emotionally and manipulative.
I would ask that he cease talking about things he doesn't have any firsthand knowledge of that are outside the scope of the timeline that's relevant for this motion.
Sir, just stick to the facts and that, not anything that you might have heard or that can't be proven.
Okay. Yeah, based on exhibits C, D, and E, my mother had temporary custody of Elijah for 6 months. And it was during this time I formed a really strong and positive relationship with our son. I talked to him almost every single day on the phone, sometimes more than once a day on the phone. And he learned to know my voice. He learned to know what I look like through pictures. As soon as the phone number popped up, he said, "Daddy's calling." And we ended every phone call by saying, "I love you" to each other. Now, Shannon met a new boyfriend, had a new baby, and ever since then, she's been trying to erase my side of the family. And I just don't think that this Revocation of Parentage Act applies here because I was not a teacher anymore and the relationship was legal.
Okay. Anything else, sir?
No, Your Honor.
Okay. Ms. Reynolds, anything else?
No, only the clarification that my client remained a minor up until the time that the child was born. The child was born when she remained 17. So that there was not, she was not an adult at any point in time that before she had this child.
Okay, thank you. Well, the court does note in this particular matter, the undisputed facts are that the defendant was convicted of CSC third. He also was convicted of a witness bribing or intimidation or interference in this particular matter. Court takes those as undisputed facts in this particular case. Court would note that aside from his arguments that during this time when this relationship occurred, the plaintiff was always a minor in these particular matters, and obviously suffering under that legal incapacity, if you would. And as a result, the court does find that the motion is well taken. The court will grant the motion revoking the affidavit of parentage in this matter. The court will determine that the defendant is not entitled to parenting time pursuant to MCL 722.1455, and the court will further cancel the referee hearing scheduled in this matter. Ms. Reynolds, you can prepare that order and submit it under a 7-day notice of entry.
I will, Your Honor. Thank you.
That will conclude this matter at 9:14 a.m. You're free to go. Have a good day. Matter. Court will note the appearance of Mr. Toth on behalf of plaintiff, Mr. Schaefer on behalf of defendant. This matter is before the court on the plaintiff's motion requesting post-judgment relief. Mr. Toth, I take it you've probably seen the answer that Mr. Schaefer has filed?
I have.
Okay. If you could, I've obviously read all the pleadings, but I'm more concerned with your response to that answer.
Well, Your Honor, preliminarily, in paragraph 18 of my motion, which is page 5, it regards items of personal property A, B, and C. I should have eliminated that from the motion. My client had that in her possession. She alerted me to that fact, and I simply neglected to redact that from the motion. So those 3 items of property are not at issue.
Okay.
Your Honor, globally, I have read the response, and what I can say is this: is that Your Honor made his ruling on February 14th, and the judgment was entered finally on May 1, 2023. A terrific amount of going back and forth, trying to resolve things. We were successful in some and not successful in the others. We have a signed judgment. It was approved by Mr. Schaefer on April 17th. It was approved by the defendant on April 19th. The focus of this motion deals with child-related issues and property-related issues. The frustration that was exhibited during the trial is manifest itself now. I think the best example is the communication app. Your Honor's probably sick and tired of hearing me talk about our family wizard. We started doing it last fall. Mr. Klein has still not proposed an alternative. So what we're simply asking is that we have an order that says the parties utilize our family wizard, that they split the cost, and my client has already set it up for this year and it's ready to go. So Your Honors, I think it took a week of back and forth as to try to interpret or to decide what we were going to put in the judgment. It says our family wizard or an alternative. We don't want an alternative, and an alternative has never been expressed. So we simply need some app, some mechanism for these people to be able to communicate, for not only communication regarding the child, but also submitting requests for reimbursements of medical bills, et cetera. Your Honor, there's almost $56,000 of my client's money in Mr. Schaefer's trust account. I don't think there's any dispute to that. It's not Mr. Schaefer's money. On April 21st, I sent him an email identifying the fact now that we have an approved judgment. In other words, everybody has signed it. It wasn't entered, but it was signed. I would like to have a staff member pick up 100% of those proceeds. Please call me on my cell. The first I heard back from Mr. Schaefer was last Friday at 4:37 in his answer to my motion. And apparently it's, well, no, your client can't have the money until my client gets his stuff back. The judgment doesn't say that anywhere, Your Honor. There's absolutely no question it's my client's money. It's been now 2 weeks, not even the courtesy of why you can't have it until, well, my client needs his snowmobile and four-wheeler, which are in my client's father's barn. My client doesn't have the trailer that was awarded to Mr. Schaefer's client. My client doesn't have a pickup truck. The defendant does. My client doesn't have keys to the vehicle. We've asked and asked and asked for dates, and admittedly, we haven't been able to agree to a date for him to come and pick it up. Apparently, the position now is no, plaintiff has to deliver that to me. And if she does that, and when she does that, she can have the $56,000 that's her money. Your Honor, there's going to be an exchange this Saturday at 6 p.m. And it's not Sunday, it's Saturday because of Mother's Day. And so what we're proposing is that at the time of the exchange, it occur at my client's parents' home, and that Mr. Klein remove his items of property at that point in time. And I'm not suggesting at all, Your Honor, that that this should be tied into then my client gets their $56,000. She should be able to get it today. In regard to another issue, Your Honor, is these Edward Jones authorizations. My client's entitled to approximately $15,000 in that joint account for equalization. She attempted to provide Mr. Klein with the documents to sign. Edward Jones itself has sent him a letter with the document in it. Edward Jones has provided it in his online account where he can take care of it electronically. This morning, I'm sending it over to Mr. Schaefer's office. It's something that has to be signed in order to effectuate this court's judgment. So, Your Honor, we've now got two issues, the money and then these authorizations. The response is something about there's Lake Michigan Credit Union accounts that have, my client should be entitled to 50% of the interest accrued on those. The balance in the account, Your Honor, is $360. The interest is $12. I can assure you that we are talking about it. Is dwarfed whatever benefit Mr. Schaefer's client will reap. And so my position is we have numbers on the equalization chart. That's what we're working off of. If he wants $6 in interest, my client should be entitled to half of the loss on that $15,000 account. It's almost $1,000. So again, Your Honor, it seems to me that has absolutely nothing to do with the implementation of your ruling. It's just trying to continue to be obstructive and drag this out. The exchange location. Exit 115 was the halfway point before my client moved, and now apparently it's the halfway point again. It's exit 110, which was fine with the defendant, and the parties got into a disagreement whether the exchange should be in the sheriff's department parking lot or in a restaurant parking lot. We believe it should not be in the sheriff's department parking lot. There's no reason for it. It should be in the restaurant at exit 110. Apparently now we've got another shift to do to construction. So we simply need, Your Honor, and it's almost embarrassing. We need the court to identify what exit and where the exchanges should occur. There's an issue with telephone video communication.
Mr. Toth, is the sheriff's department at exit 110 or close to that?
It is.
Okay, thank you.
The communication, Your Honor, we're operating under the premise that fundamentally it's appropriate for a parent who is not with the child to be able to communicate with a 4-year-old. Universally, I have found that to be true not only in Calhoun County, but in any county I've ever practiced in. And we have I guess it should not be a surprise to anybody that we have a problem with what the schedule should be. So in paragraph 6, I proposed a schedule. The answer just seems to suggest, I think, that there shouldn't be any communication. I don't know identifying why that's best for the child. And what we've proposed is pretty straightforward. The defendant's parenting time, Your Honor, is alternate weekends, 3 days, Thursday night to Sunday. And so we've said on Saturday, our client should have the opportunity to communicate with her 4-year-old. During his extended times, which would be spring break or Christmas break or summer, that it be on a Sunday, Tuesday, Thursday. We've identified again the times, and then we've gone as far as to suggest that when the 4-year-old is with my client, the dad can contact the child every other day between 6:30 and 7:30. No alternative was suggested other than identifying in 500 words why my client's a horrible person. Your Honor, this is about communication for the child. We have to get beyond the parties. This isn't about the parties. This is about the 4-year-old and what's best for him. And I just can't fathom how it could be concluded that the contact is not good. The personal property, Your Honor, I've already touched on those 2 items. It's again, the defendant wants my client to deliver. For the life of me, I can't understand. I can't understand that. We've identified the RC race cars. We couldn't post ruling, settle the property issue. My client's entitled to see these things, and she should see them immediately and choose what she wants. And Your Honor, this isn't $50 or $100 property. These things are worth thousands of dollars. Those need to be available. And then we've identified in paragraph 18, again, eliminating A, B, and C, the items of personal property that my client did not receive. It was covered during the trial. It was covered during cross-examination, and it hasn't happened. So, Your Honor, I don't understand this. First of all, somehow suggesting that the motion is premature. We have a judgment. We have problems, Your Honor. My client has faced with $40-some thousand in credit card debt, and she'd like to be able to make a contribution to that. Whether she does or doesn't isn't relevant, other than for the court to understand why this is an important issue. And to have the response, not even the courtesy of, well, you can't have her, she can't have her money, even though the judgment says she's entitled to it, just absolutely defies logic. So, Your Honor, I looking at the wherefore that we have here, our prayer for relief in this case, I think we've covered everything that we're looking for, other than, I guess, the portal. And as Your Honor will recall, during the trial in this matter, we were portaled to death. Mr. Klein says he won't use it. My client purchased it after the case was started, and she's saying, can I have it back? I can use it. Why he would want it, who knows? So, Your Honor, I do believe that the relief requested is appropriate. The prayer for relief, again, when I look at this, as much time as we spent on this to be where we are, we need it resolved. We don't need to kick the can down the road anymore, Your Honor. We're going to be with you until God knows when. We need to have some closure to issues, and all of them I've addressed are legitimate. And if somehow to suggest, well, you filed the motion before the judgment was entered, what does that have to do with what we're doing today? The judgment is entered. The judgment was approved by both parties before I filed my motion. So to somehow suggest there's some procedural defect that should prevent us from addressing this today, we have an answer. We have the motion. Your Honor's familiar with the issues. There's no reason we can't resolve this today. Thank you.
Mr. Schaefer, you can respond.
My response, Your Honor, and I spent a lot of time trying to respond appropriately. This motion is premature, and in spite of what Mr. Toe says, it was not approved on the 17th of April. It was approved on the 27th of April, after, in fact, it was filed. The date on plaintiff's signature of approval was the 27th of April, and that was after. So I had no approved judgment. In all due respect,
excuse me, Your Honor, that's when my client approved it. Mr. Schaefer approved it.
Okay, let's not argue about that. The judgment's been entered at this point, so let's move on.
So all I'm saying is that we are chasing ghosts with the plaintiff here when she apparently under oath says that she hasn't received things that were delivered to her on April 19th, required us to give photographs of that transaction. Your Honor, there is a beaucoup of things here that are all one-sided. She claims that she has $56,000. No doubt, it's in my trust account. And when a judgment got entered, it will be made available in a reasonable period of time. My client doesn't have $56,000 coming. He has over $5,000 coming on property that she has kept from him and will not deliver. And the question is, oh, well, she doesn't have the trailer now. Well, the trailer that my client has was in disrepair and it is inoperable. They moved, plaintiff moved with her help, whoever that was, these two items and are storing it someplace. And in all due respect, whether she has keys or not, she didn't have keys before. Keys aren't going to help. I anticipate these two items have been there for over a year with dead batteries and everything else. They're going to have to be manually put into a trailer and delivered. We're asking that be done because she has requested everything else to be delivered to her, which we have done pursuant to her request. In addition, opposing counsel neglects to talk about the items that she has not delivered on the list and still remains undelivered. So that is an issue that has to get taken care of. And now we hear again about the wizard. Apparently, plaintiff hasn't read the judgment that she approved and I approved. It makes the wizard the app. It does not have the language that was negotiated. It was agreed to. The language was put into the judgment. It doesn't have or third app as your honor ruled, but that was negotiated and we agreed to the wizard. And now we spent 2 or 3 paragraphs dealing with another non-issue as we did with the other part. This is becomes harassment and expense. And she cries, well, I've got all this debt to pay. Well, my client's got debt to pay and he doesn't have the liquidity of that to be done. It was a premature motion. The judgment is entered now. I understand that, but that was 2 or 3 days after the approval took place and 2 or 3 days after this matter was filed. Your Honor, other things. We have not received any authorization that has been alleged herein. Plaintiff claims that she gave a copy to the defendant. She did not. She offered to give one to him if he would sign it. He says, I got to take it to my lawyer to find out what it says. She wouldn't do that. She took it back. My client has not received it. I have not received it. I don't know what this authorization says. If it's a proper authorization when received, it will get taken care of. But to sit there and suggest that we are sitting on some authorization that we're not signing, I don't know. The argument about the interest and the accounts of stock are different. And that was part of negotiations. And again, to refer to things that are in negotiations are improper under 408, but that was talked about at that period of time. Your Honor, there are many other things here that are just such as the exchange point. The exchange point was not ruled on by Your Honor during the trial. The exchange point was 115 on the prior order, was in effect until there's a written order contrary thereto, and plaintiff has not complied with that requirement. She has dictated where she wants the exchange to take place. She testified at the trial that the 115 was the midpoint. She testified at the trial that when she moved, it was no further away. It was still the midpoint. And so she is resisting that for whatever reason. She says, well, it's got to be at 110 at the free range. Why? Because the free range is not open at that time. We had, again, this negotiation is probably improper to even be brought up at the sheriff's department. That was at a time when the plaintiff made accusations against the defendant at an exchange of inappropriate behavior. So he says, I need a place that is public. Now, 112 is 2 miles down the road, and that is an alternative if the 115 is not concluded or continued. But it should be continued because it's been testified by both parties that, in fact, that is the midpoint. In relation to the $56,000, certainly that should be made available. So, but all the other properties should be made available too. His $5,000 worth of 2 machines, a 4-wheeler and a snowmobile, should be delivered to my client, as I will deliver the balance of the $56,000. Just for other items, the judgment indicates that the defendant has $5,000 coming of attorney fees as of 2 days from today. I am suggesting that be extracted from the $56,000 figure and the balance returned. I suggest that the snowmobile and the four-wheeler be delivered forthwith to my client. The dictation of a date when we have no control over where it is, the condition it is, it's in control of plaintiff, it should be delivered. The other items that we responded to on the exhibit should be made available and delivered to my client forthwith as set forth therein. Your Honor, we spent a lot of time making the situation between these two people worse. Let me talk about a little bit about the video and the contact with the child.
I don't really need that, Mr. Schaefer. I'm going to make a ruling on that, and that'll take care of it.
I know you will, Your Honor, but for the record, I need to make this because to suggest every other night during the vacation periods is just plain obstreperous. And it causes difficulty with the child. As indicated in our pleadings, historically, number one, she would not return any calls from my client when he wanted to talk to the child. In addition to that, when she did have FaceTime with the child, she spent most of the time encouraging the child to come home with indication of gifts, indication of that the dog misses you, so come on home, and then it just causes problems with the parenting time. My client has precious little parenting time. He wants to enjoy it. He does not want to set forth time dealing with the mother of this child. In addition to that, Your Honor, if there is going to be a parenting time, I think it should be minimal. Maybe once during a period of a week would be sufficient. That it be instituted during the time period by the person who has the child. Thus, the child's time is going to be not inconvenienced more than the parent's time. If the parent has to be inconvenienced for an hour to be available to receive it, at least the child can have that decision made by the parent with the child to coordinate with the activities of the child. And I think that's the way it should be in that regard. Your Honor, I think that this is a motion that is more harassment than anything else, especially today. We find out that, oh, oops, I misunderstood and the property was returned. And if you look at the judgment in relation to Wizard, it's another oops, oh, I guess we did agree to that. So those are non-issues that we had to spend time dealing with that nonsense. I'm respectfully asking that if in fact my client has been required to deliver property to her, which he has done, that she be required to deliver property to him that she has in her control. She dealt with it without keys. She can deal with it now. Each one are going to have to hand load these two items onto a trailer and deliver them to my client. I ask that there be a date that be given to happen. I don't have any problem with a reasonable date of delivering money to Mr. Toth that's in my trust account. That's what should happen now that a judgment is signed. That should be done. But the other matters ought to be done also, and I would respectfully ask that that happen. I rely, Your Honor, on this portal. What is a portal? Is it an iPad? What is it? It's a piece of, as we understand it, it's an iPad that Dakota uses at his father's. This is just one piece of property that was not litigated, was not ruled on. Others were talked about. There were 8 totes of property that plaintiff took from the cabin that she's never accounted for, but it was never ruled on, as the porter was never ruled on. To pick out one of these and say, oh, you've got to return this item, but we're going to disregard the rest isn't appropriate. If we're going to go back and reopen property to be divided up, I guess we need to deal the whole thing, which is absolutely ridiculous. I think the intent of the judge's ruling, if it wasn't ruled on, it stayed where it was at. And I think that's what this situation is. Now to deal with this on that basis, I think is inappropriate.
Mr. Schaefer, where's the what exit is closest to the sheriff's department? I hear 110, 112. Where is it?
110 is the exit. That's the old 27 that goes to the sheriff's department. 112 is the Loves, which is a public place that can be gotten there.
Okay, thank you. Well, what the court's going to do is obviously there's a bunch of disputes, but the court is going to rule that the parties would meet at the sheriff's department off of exit 110. Resolve that. We'll have, evidence, and we have sheriff to be able to intervene in the event that it's necessary. The court will not address property that was not ruled on, that property will remain with whoever has it in their possession. The court would order, as the parties had agreed, that they would utilize the Our Family Wizard app in this matter. The court would allow communication by video with the child one time that the parties, when the child is with the other parent, and that would occur on whatever the time is halfway between. So if it's a weekend, it'd be the, let's say 3 days, it would be the second day then, and that's for both parties. So either way it would apply, and it would occur between the hours of 7 and 7:30 p.m. on those particular nights. One time, the parties would not talk to the child about coming home or going wherever, and they would not, again, address any gifts that are waiting for the child if the child comes home. The court would order that the escrowed funds would be released immediately in this matter, that the defendant would sign whatever paperwork is necessary to get the funds from the Edward Jones account. He would do that within 7 days of today's date. Failing to do so, the court would enter an order that would release those funds to the plaintiff in this matter. The court would order that the parties would meet at the plaintiff's parents' home on May 13, 2023 at 6:00 p.m. And the defendant would pick up the snowmobile and the four-wheeler. He would deliver the remaining property listed under paragraph 18 of the petition, as well as he would provide the RC cars, accessories, and components at that time for the plaintiff to pick which ones she would like. The court would also order that within 7 days, the defendant would sign whatever paperwork was necessary for her to acquire the account that held the $360 in the bank at that particular time. The court's not going to address issue of interest because I'm not going to address the losses or anything else as well at this particular time. So that would be the order. Mr. Toth, you can submit that order under 7-day notice of entry.
Your Honor, for point of clarification, in regard to the telephone communication, what the defendant has been doing is he'll call and hang up before there's a ring and then have evidence that he made the call suggesting my client didn't answer, which is why we're asking that the order reflect that the party who is not having Dakota with him or her initiates. In other words, if the 4-year-old's with dad, that my client initiates the call.
Yes, that would be the intent, because I said it's between 7 and 7:30. I don't know if they're going to call it 7:05, 7:15, whatever it may be. The intent is that they would initiate that call if they want to speak to the child. If they don't initiate it, then they don't speak.
Very good.
Okay. Mr. Toth, you can prepare that order, submit it. Court
Your Honor,
so.
Your Honor, I have clarification request, please.
Okay.
You ordered that within 7 days, this authorization must be signed. We don't have the authorization. So I guess I would respectfully ask that it be 7 days after it is presented to us in some fashion. I haven't seen it.
That would be fine. Mr. Toth, provide them the authorizations for both that and the other account, whatever is necessary, then they have to provide the back to you within 7 days of that date.
I will do so. Thank you.
Okay. Thank you. Court will end this matter at 9:50 a.m.
Your Honor, I have
What?
further clarification, please.
Well, please express it. I'm not taking on mourning on this case.
Well, I understand that, but Your Honor, May 13th, that was at her parents' home?
Correct. That's what I stated.
Okay. I guess that's the last clarification I got, Your Honor.
That's it, Mr. Shaver?
That is, Your Honor.
Okay, thank you. We'll conclude at 9:51 a.m. Matter before the court on the defendant's motion to set aside default. Court has reviewed all the pleadings in this particular matter, so I don't need you to reiterate those. Go ahead, Mr. Vanderhorst.
Thank you, Your Honor. Plaintiff filed a claim for divorce on or about October 21, 2022. Acknowledgement of service was filed with the court stating defendant was personally served on or about 11/17 of 2022. On the date that he was allegedly served, it was sheriff's, I believe, came up through the documents on his windshield. It was during the period of the early November snowstorm. Documents were ruined by the snow. Mr. Hans did not know they were divorce documents. If he did, he would have responded to the complaint for divorce and also attended the motion hearing on November 28 of 2022. After the motion hearing, plaintiff was granted exclusive use of the home, sole physical and legal custody of the minor children, and supervised parenting time to defendant. Parties have 5 minor children. The parties also have property and debts that need to be divided. Defendant would like an opportunity to participate in all future court hearings and also for the court to set aside the default. What he's asking for today is to order the parties to attend mediation, and if a settlement agreement cannot be reached at mediation, to set this matter for trial. Thank you, Your Honor.
Okay, thank you. Ms. Capture?
Thank you, Your Honor. Like Mr. Vanderhorst just stated, this case was filed back in October. It was set to close on April 21st. Right as we were preparing to file our judgment of divorce, we were served this motion to set aside along with defendant's affidavit. The misstatement here is that the Sheriff's Department did not ruin the papers. Mr. Hans knew full well that he was being divorced. He's been in the middle of a criminal trial for domestic violence, which he has pled guilty to. He has also known about the orders because he's been properly served multiple times by first-class mail at his current residence, which is his father's house. The motion hearing itself was re-noticed and set for November 28th. It was originally noticed for November 17th, I believe, or potentially a little bit. November 21st. I apologize. Again, Mr. Hans was also served with the default judgment in this matter and did not object in a timely fashion. We've been at this for approximately 6 months. Mr. Hans has my contact information, has not contacted me, has contacted Ms. Hans through My Family Wizard, which he uses in part for the child custody issues, but also because he violated his no contact order and his PPO with Ms. Hans. And that is currently pending in front of the court for violation of his no contact and PPO. Currently, Judge Tomac has ordered that he is not even to contact her through My Family Wizard at this time. Again, Mr. Hans has had ample opportunity to participate in this matter. Setting aside the default is against the interests of justice at this point. We would respectfully request that the motion be denied and to allow Ms. Hans to proceed with filing her judgment of divorce. Thank you, Your Honor.
Thank you. Well, what the court's going to do in this matter, the court will not set aside the default. The court believes it is proper and appropriate, but the court will, however, allow the defendant to participate in disputed matters. We'll set the matter for mediation. Mr. Vanderhorst, who would you like as a mediator in this case?
John Brundage, Your Honor.
Okay. Ms. Capture, is there any problem with Mr. Brundage serving as the mediator?
I have no objection with that.
Well, what the court will do is we'll set it for a mediation in June. That may be difficult. I know Mr. Brundage was actually going into maybe July for some time in mediation, but Mr. Vanderhorst, if you contact Mr. Brundage today, you may still be able to get one of the last date in June, if not have it in early July. And that will be the order of the court. Mr. Vanderhorst, you can prepare that order, submit it under 7-day notice of entry.
I will, Your Honor. Thank you.
Okay, thank you. The court will conclude this matter and the defendant. This matter is before the court on the plaintiff's motion to quash defendant's subpoenas in this particular matter. The court has read the pleading, so I don't need you to reiterate all of that because it'll just require us to be here much longer. If you can simply respond to the other pleadings or anything you believe is germane to this matter.
Absolutely. Thank you, Judge, and thank you for taking the time to hear this. We are trying to quash the subpoena because we believe that it seeks to find privileged information and also information that's no longer relative. You know, in the defendant's response, he says that it's not privileged, but then in paragraph 13, he does admit that the information sought, and this is a quote, will likely be supportive records, notes, data, reports. This is, again, the situation that we don't believe would allow this subpoena to go. This is relevant insofar as it's privileged, rather, information about my client, her conversations that were done in the course of her being a patient, essentially, of Ms. Rosenbaum and of Ms. Katz in this regard. He has joint legal custody, so he can get reports about the children's sessions. The counselors can also be called as witnesses, and to state that wouldn't provide him time to prepare doesn't really seem something that is applicable to this case. And so we would ask that you quash that subpoena that would require my client to produce this privileged information about her conversations with these doctors.
Mr. Reed, how is it privileged if the court ordered that counseling to take place?
Again, because it is my client's relationship with Ms. Katz and with Ms. Rosenbaum that he seeks to gather. And so.
But the court ordered that. So if the court ordered it, it's not like you went to some counselor, you know, let's say in Lansing or something of that nature. It was pursuant to court order. That information is not privileged then if, again, if it's court ordered.
But those women have provided reports and they've provided their opinions. They've provided ample information to both parties. What he's seeking goes above and beyond what the court has ordered. He wants these text messages that go back and forth between my client and these women that is likely to have information about her own treatment. That is the privilege that we're seeking to stop. Furthermore, you know, the burden of providing and compiling and going through this information is going to outweigh the benefit that they receive from getting that information.
Okay, thank you. Ms. Canfield, what's your response to that?
Thank you, Your Honor. Well, I obviously disagree. I believe that all the information is relevant and admissible. I don't believe that it's privileged, and anything that would be considered privileged could be reviewed in camera by the court to determine if that is something that is helpful to the defense and something he cannot otherwise obtain, but from the plaintiff and these women. The demonstration of these facts is that basically Ms. Galt's communications with both Ms. Rosenbaum and Ms. Katz will demonstrate to this court her behavior since the time this last order was in place, perspective to the best interest factors that the court will be considering at a full custody hearing soon. Additionally, it will demonstrate that the plaintiff has continued to violate legal custody by changing and arranging counseling appointments for the children with these therapists and not notifying my client of the same. It additionally will demonstrate that she created a conflict of interest by individually counseling with the children's therapist, as opposed to just with Ms. Katz for the reintegration therapy. That has demonstrated then her ability to influence the child therapist's opinion regarding this case, who will not keep and has not kept any appointments with my client, refuses to talk to my client, and quite frankly, doesn't want to give me a lot of information or communicate with me either. Any reports or therapy notes or anything upon which each of these therapists would base their recommendation to this court and to provide and as a basis of their opinion is discoverable under MRE 703 and 705. In fact, it has to be in evidence if the court's going to consider their opinion based thereon. So it absolutely is discoverable and relevant. And I think it goes to many factors that the court will need to ultimately determine in this custody and parenting time dispute. So I would ask that the court dismiss the motion to quash and order the subpoena response.
Okay, thank you. Ms. Reed, anything else?
Only to say that I think it's important for this court to know that both parties have already agreed and stipulated to use a new counselor. And again, so this information, we don't believe is going to provide the information that they're seeking. And it's really not going to be relevant as this court continues to move forward with the case. They have a new counselor in place that's going to be charged with doing what this court's asked.
Okay. Well, the court does note that Michigan Rule of Evidence 401 does state relevant evidence is evidence having the tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. The court does deem this to be relevant in this matter. And as I've already stated, the court ordered the matter into counseling. And as a result, that would not be privileged. So what the court is going to do is the court is going to deny the motion to quash at this particular time in order that in fact, information would be provided pursuant to the subpoena. Ms. Canfield, you can prepare that order and submit it under 7-day notice of entry. The court will end this matter at 10:12 a.m. You're free to go. Have a good day.
Judge, briefly, may I just, Ms. Canfield, I think, was suggesting that since that subpoena is ordering that information today, that she would agree to allow a bit more time for us to provide that information to her.
Well, I assume you're going to have to. I don't assume you're going to get it today. So,
okay.
What, Ms. Reed, would you be able to do that within a week?
I believe so.
Okay. Why don't we, Ms. Canfield, why don't you put it in that it would be provided a week from today? On behalf of the plaintiff, Mr. Bartel, on behalf of defendant, this matter is before the court on the plaintiff's amended motion to enforce consent order of custody and parenting time. Just to clarify, Mr. Bartel, if you would, you had mentioned that about the documents to get the passport. You said that you've completed the new forms, but you didn't say whether that had been exchanged. So was that provided back to Ms. Capture?
Yes, I believe my assistant physically dropped it off last Thursday. What had happened before is Mr. Brunish was prior counsel and they did fill it out. And I guess that it was filled out in blue ink and it was notarized, but it didn't have the raised seal.
Okay, so Ms. Capture, you have that, so that's a non-issue at this point, is that correct?
Yes, Your Honor, that is a non-issue. However, we still would like to amend the order in order to allow plaintiff to travel to Thailand with the minor child.
Okay, and I have noted, Mr. Bartel, if you see the response from the plaintiff, she's stating that if the child travels to Thailand, that child will be in Bangkok, so the child won't be by any of the areas that you've stated are there's insurgent activity. What do you say?
Well, Your Honor, and I think the government in general has them at a different level. Thailand in general, those were additional ones that were even higher. So we still do not believe that the child would be safe in Thailand from that perspective. But furthermore, Your Honor, overall, there's been, especially in the last 3 or 4 years, erratic behavior by plaintiff in this matter that has shown that she has hostility towards authority figures. And we outlined that in our response as well. Furthermore, there has been a history here in which plaintiff's own parents have tried to have my client sign off on the minor child, indicating to my client that they'll take care of the child and there'll be a much better life for the minor child in Thailand. Obviously, that's of great concern. We believe that there is a high likelihood that the minor child will not be returned back here to the United States. It is my understanding that plaintiff's father is extremely wealthy in the Thailand region. He actually has a dual citizenship with, I guess, the Chinese national government. His nickname was the Bandit, and he makes his living counterfeiting. There's a lot that's going on here, Your Honor, that give us great concern that the minor child will not be coming back home. By way of example, Your Honor, of the erratic behavior by plaintiff, she does not follow the rules at school. I see that there was an email provided by the plaintiff indicating that something about both parties getting along or not being able to be on the school property. Since that time, the plaintiff in this matter was actually told she cannot be on the school property by the principal when defendant is trying to drop the child off. And what does she do? She shows up in a different car. She keeps harassing my client and she refuses to comply with the school with regards to that. She calls the police nonstop on my client, and she is claiming that he's a racist, that he steals electronics from the minor child and is returning them. I mean, it just goes on and on and on. And she constantly is harassing my client. This matter was before Judge Yost Johnson at one time. She ordered co-parenting counseling. My client showed up 3 times and she didn't show up at all. And she says, well, I didn't know that there was any co-parenting counseling. So, Your Honor, there's a lot of issues here with regards to whether or not she's going to bring the child back. We outlined it in our response. And I would like to also note, Your Honor, it's very interesting that my client wanted to take the minor child that exact same date. And he texts plaintiff back in January of this year to San Juan Islands, which is in the United States jurisdiction. And she said no, that she wouldn't allow that. And now she picks out these same weeks to say she wants to go to Thailand, Your Honor. That obviously in this court has equity. Obviously the games that she's playing just further show the lengths that she's willing to go to keep the child from my client, let my client do anything with the child. And if I could, Your Honor, I still am going to circle back just because Thailand is part of the Hague Convention. I do not believe it allows, or, obviously it's this court's decision, but I don't think it's an automatic agreement to allow my child to go to a particular region. Thailand has historically had high crime rates. There has been historically a lot of, abductions over there, human trafficking, especially with young girls, especially young girls that are not of the native land, which we have here, Your Honor. So I did point out some different regions, but in general, you can go to the government's website. In general, there is extreme caution with regards to Thailand in general. Those ones were even higher, Your Honor. So we respectfully ask that this court deny it.
Okay. Ms. Capture, any response?
Yes, Your Honor. First and foremost, due to defendant's delay in this matter, Ms. Lertnemitter cannot schedule a trip this summer to be able to go to Thailand. However, the issue does need to be discussed that she be allowed to see her family. Her father is very ill. My child's grandmother is very old. There's not a lot of time left to be able to make these connections. So it is important that the minor child be able, one, to experience her own culture, and two, to be able to have close relationships with her relatives. We would request that this be set for an evidentiary hearing. Mr. Defendant has stated multiple untruths. In part, the co-parenting counseling, the parties did go to co-parenting counseling. Defendant left halfway through, stated it wasn't working and he wasn't going to participate anymore. We can bring witnesses that attest to that. We can also then bring evidence that says this area where Ms. Lertnemitter and the minor child will be going is not dangerous to the minor child. She will be with family. There is very little risk then for Ms. Lertnemitter to take her there. She speaks the native language. She'll be at home. Again, Ms. Lertnemitter has a career here. She has a home here. Her home that she's owned for over 6 years. There's no reason for her not to come back to the United States. For her to, or for defendant to say that she's just going to abandon her job and her life here is a bit of a stretch. So we're asking that this be either set for an evidentiary hearing or that judge amends the order to allow for plaintiff, once she finally receives the passport, to go on a bona fide vacation that doesn't conflict with plaintiff's vacation or defendant's vacation time either.
Okay. Well, in this matter, there are a lot of issues raised. Again, in the answer, we've addressed some of those today. Obviously, it appears that the defendant had, in fact, informed her of time he wanted to take a vacation, and coincidentally, she wants to take the child to Thailand at the same time. Obviously, the parties have had substantial conflict among themselves and a lot of contention in this matter. It's been argued by Ms. Capture that, well, the child should be able to, in fact, develop a close relationship with the family, which would, again, denote to this court that she doesn't have that relationship as of yet. So the court does question the propriety, if you would, of, again, going at this time to establish that. But at this point, being that she cannot travel, again, apparently this summer, the court is going to deny the request. The child would go to Thailand at this time. She can renew the motion in the future in the event that, again, things have changed. But at this point, the court will deny it and ask Mr. Bartel if you would prepare the order denying that motion and submit under 7-day notice of entry. Court will conclude this matter at 10:24 a.m. You're free to go. Have a good day.
All right. Thank you.
So when do you want to go on
Ms.
vacation?
Reed, on behalf of the plaintiff, Mr. Toth, on
Sorry,
behalf
one
of defendant, this matter is before the court on the plaintiff's motion for temporary custody, parenting time, and support. Ms. Reed, in answering and reviewing Mr. Toth's answer, he states that the last weekend, I don't know if it meant this last weekend or the weekend before his answer, that the child had spent the weekend with the defendant in this particular matter. Is that accurate?
I believe it is accurate that she did have parenting time with her dad. Again, this is, the second time this year that that's occurred, and
Okay.
I don't think it changes the established custodial environment of the child.
Okay. Anything else? And again, I don't need to reiterate the pleadings. Anything else you'd like to highlight, Ms. Reed?
I mean, only to state that essentially this minor child doesn't have a very strong relationship with her father. She is not particularly well bonded with him because of the inconsistencies in the parenting time order. And so we're asking that you would grant my client primary physical custody. And because he does not participate in schooling, daycare, doctors, anything in that regard, we're asking for legal custody to go to the plaintiff as well. We have concerns about the use of alcohol that was occurring, the use and abuse of alcohol. And so we're asking that there be a prohibition on alcohol use during any parenting time that Your Honor is inclined to grant to the defendant father. And also with regard to overnights, we don't have adequate information about this third party, this other young man that's living with the defendant. And we have concerns about his safety, his criminal history, to put a young 5-year-old girl into this place where we really don't know who he's living with. We don't believe there's adequate sleeping conditions for her. And so we're just asking Your Honor to take that into consideration when he's granting.
Okay, Ms. Reed, how would you're stating that you have no information about this individual, but you're concerned about his criminal history and all that. How can you do that if you have no information?
Well, that's precisely my point. We'd like to have that information so we can determine if this person is someone that's safe to be having residence during this small child's parenting time.
Okay. Mr. Toth, anything else other than what's in your answer?
Your Honor, I would simply add that the timing is interesting. This is a temporary order, and we do acknowledge that. There's no reason my client shouldn't have joint legal custody, none. We're almost right up to summer break period. I would suggest that at the very least that a standard vacation schedule be established from here on out, even if it's alternate weekends from here to get to that point. I think by the end of the summer, we should have this case resolved. And I would finally add that my client would be agreeable to a provision that there be no consumption of alcohol during his parenting time. And again, reiterating that all of these expressed concerns did not manifest themselves last weekend.
Okay. Well, what the court will do in this matter, the court will on a temporary basis grant temporary custody to the plaintiff, support pursuant to the guidelines. The court will grant to the defendant standard parenting time commencing this Wednesday at May 10th. And again, what I'll do is then have the alternating weekend start on his alternating weekend start on the 19th, because this next weekend being Mother's Day, he would not have the full weekend. So if we start on the 19th, then he would, and then just the other standard holidays, vacation periods, etc. Court would order, as he's agreed, that he would not consume alcohol during the time that he has the child in his care. And Ms. Reed, you can prepare that order and submit under 7-day notice of entry.
Thank you.
Thank you. The plaintiff will conclude this before the court on the plaintiff's motion for modification of custody, parenting time, and support. It's been alleged in the motion that since October 2022, that the parties have alternated the custody of the children on an alternating weekly basis. Now, for the defendant, is that accurate statement?
Yes, it is. They've been going back and forth, switching on Fridays.
Okay. So you're not disputing that, again, you're not disputing the fact that, again, he's had children on an alternating weekly basis. Are you disputing that should continue?
No.
Okay. Ms. Reed, does it sound like that is resolved the particular motion that you have?
It solves one of the issues. The issue that we're going to be having is regarding the child support recalculation. In speaking with the defendant, she's currently working about 4 hours a week, making $25 an hour, I believe, as a nurse's aide. And I believe she's voluntarily underemployed, and we would like to impute her at least a minimum of $15 an hour for 40 hours a week, as if we would use her actual income, it's grossly insufficient, and it is unjust to give her maybe $400 a week. No, that would be $100 a week for $400 a month under the child support calculations. And she does have experience working as a nurse's aide in a hospital. Okay. And so we would need an imputation of income.
Okay. To the defendant, ma'am, what's you're working on a limited basis. Is there any reason that you couldn't work on a full-time basis?
She had the hours wrong. I work 2 to 4 hours a day, 5 days a week, depending on my patient's needs. It could go up. Depending on his needs, it was up, but then it is not anymore because he doesn't need that. I am the person that takes the children everywhere when they're needed. I pick them up from school. If they're sick, I have to take time off of work when I had a regular full-time job. Troy never did that, ever. I lost a lot of hours doing that. He never took time off work for them. It was always me. So my 4 hours a day, 5 days a week works out for me and my children. Okay.
Well, Ms. Reed, if again, calculating her current income, if she's working those 4 hours a day, 5 days a week, that'd come out to a gross of $500 per week, as opposed to it'd be $600 if it was, again, imputed 15 hours, et cetera. The court will take her $500 as her income, and you can calculate support on that basis in this matter. The court would, even though we're going to alternate the court will grant joint physical custody, joint legal custody, and alternating weeks. The parenting time, but the court would also grant the alternating holidays as well, and you can include that, Ms. Reed.
Okay.
Okay. I think that will conclude all the matters before the court. The court will end this matter at 10:30 and defendant appearing in pro per. The matters before the court on the plaintiff's motion to enforce judgment. The motion states that in fact the defendant is in contempt for having failed to refinance the vehicle, the 2020 Dodge Ram, and failing to again refinance the home within the 90 days from the from the January 4, 2023 date. Sir, have you in fact refinanced the vehicle and the home?
No, the vehicle is a lease, and it is paid. And I've got the confirmation number for that. And the house is currently listed for sale.
It is listed for sale?
Correct.
Okay. Ms. Reed, with that information, does that change your motion?
It does not, Your Honor, because the issue is that my client's still attached to that vehicle and it is affecting her credit negatively. And if he starts missing payments again, her credit is going to decrease. So we need something to be done to remove her from the liability on that vehicle. It's my understanding that the house was listed for sale last week after our motion was received by the defendant. And we are also requesting a specific order that says the proceeds from the sale of that home will be divided equally, with my client receiving an additional $1,800 to cover the arrearages and the child support that was referenced in the judgment of divorce, to alleviate any confusion with the realtors and the issuance of that final proceeds check, because we don't want to come back here again fighting over the amounts. And then we are asking for our family wizard to be implemented due to the text messages and the nature of the text messages that the defendant is sending to my client. Another issue that has been brought up: when the defendant received our motion, he sent my client another text message, and I have great concern that he is now punishing the children because he's upset with what was in our motion, as he told my client that, quote, "We will only communicate through the court system, and you can lose the ability to see any pictures, videos, or FaceTime with your children." It is a common practice that when the children are in the defendant's care, that they will FaceTime mom whenever they want. And now he's trying to remove that ability, and I believe we need an order that says that children can continue to FaceTime with their mom whenever they request, and that would be in the best interest of the children.
Okay. Sir, do you have any problem with the kids FaceTiming the plaintiff?
My only concern, the reason that text was sent is I don't, obviously we have a volatile relationship, and I'll just say that obviously I'm hurt and distraught with this. And when my buttons got pushed, I've said some things that are obviously very unkind. I have no problem with the kids FaceTiming. What I don't want to happen is that I get in trouble for text messaging when I'm supposed to be using the court-appointed app, and I'm not real familiar with it. I've never dealt with it before. So that's kind of what I thought was the only way that we could communicate.
Okay. Well, in this matter, typically when we have issues like this, the court does order that the parties would communicate through our family wizard. And the reason we do that, sir, is that the court would then have records of those communications, and then we don't get any false claim that somebody said this or somebody said that or responded in a particular way. So the court will order that the parties would communicate through our family wizard app, and that would be the means of communication, so that the court does have access to that. The court would order that the house would be continually listed for sale, and that the court would order as well that within 14 days of today's date, the defendant would assume the debt on the 2020 Dodge Ram, and whether that requires that you release it or whatever you have to do, that you would do that within the 14-day period. In this matter, court will at this point reserve on the any additional relief requested in this matter. Ms. Reed, you can prepare that order and submit it under 7-day notice of entry.
So I'm going to exclude the sale of the proceeds being divided right now.
I'm not going to address that now. What does the judgment provide as it relates to the proceeds?
So the judgment states that defendant shall pay the plaintiff within 90 days from January 4th the sum of $40,000, representing her share of the marital home's equity, along with $1,800 to cover child support arrears. Since he's not refinancing and sale or any saling, that's why we're requesting that the equity be divided equally with the addition of the $1,800.
The court would include that, yes, Ms. Reed, the $1,800, include that as to the payoff upon the sale of the house, and that those funds would be paid first before distribution to the defendant.
Your Honor, last week, my finance guy that is financing my home and purchasing the vehicle contacted Miss Reed and offered to wire money already last week. We also needed a quitclaim deed that the judgment states should have been prepared by the plaintiff, and it has not been. We have not received that yet. And in addition, we're ready to send the $41,800 last week, but we have not got the wire instructions.
Ms. Reed, prepare the quitclaim deed, have your client sign that, and then in this matter, Mr. May, what we'll do is you can then arrange at that point to exchange the money for the quitclaim deed. You can do that through Ms. Reed's office, and then hopefully that resolves the issue.
It's my understanding in talking with the alleged refinance officer last week is that officer was going to be preparing the quitclaim deed because under the judgment of divorce, it doesn't say that my client's to prepare it. But then Mr. May sent the same text message saying, in order for the deed to be signed, we need both attorneys present, and I don't have another attorney on the other side, and an officer with the Battle Creek Police Department. And I haven't received any further communication from his loan servicer or any sort of communication that the wire transfer would be done or any sort of deeds to my office.
Well, Ms. Reed, you can communicate with whoever it is that's doing the financing on this and arrange for the exchange of the deed for the money, and that should be something that'd be relatively easy to do. And if you don't, bring it back in, but hopefully you can arrange that with that other financial individual.
Okay, so for purpose of the order, we're going to, instead of saying divide the proceeds equally, it's that he's going to deliver the 1,800 plus the 40,000 from his loan servicer, and then we will prepare the deed and exchange it then.
Yes. Okay.
We also,
thank you,
Judge. I got a lien on the. I've got a notice of a lien from the previous counsel for Amanda that I was told by my attorney, Mike Toth, that I need to pay him the 8,000 and 700. I don't know what the exact amount was. Just shy of $9,000 needs to be paid to him, and then he pays Courtney Sierra. If that comes out of the 40,000, that's what we understood. So,
Ms. Reed, are you aware of that lien?
I do not have a copy of the attorney's lien, but I think we could request it and see what it says.
Okay, Mr. Travis, Mr. May, could you provide that to Ms. Reed? Because obviously the court's not going to require that you pay that money, and then you also have to pay the lien as well. If there is a legitimate lien, that monies would come out of the amounts owed to the plaintiff in this matter. And if that is an issue, what the court would do is, if you can't resolve that, what I do is on the monies that are paid by Mr. May, Ms. Reed, I would order that, again, those amounts would be to cover the lien would be held in escrow by you. The other amounts could be released to the plaintiff, but I want to be able to release that lien so that Mr. May can have the house free and clear.
Yes.
Okay. Thank you. You can prepare the order, and we'll end this matter at 10:40.
Just so I'm clear, as soon as because we talked, the 40,000 already included the equity in the home. That was part of it, and I inherited the debt, and that was part of our mediation and the sale of the home. Obviously, because I couldn't refinance it. I tried and I wasn't able to, and so that's why I had to go through the other lender and use the house as collateral. So,
I don't know what you're saying, Mr. May, because that's a non-issue. They're asking for effectively the $41,800 that takes care of it.
Yeah, we're ready to send that as soon as we possibly can.
Okay, well then do so. Thank you.
Thank you.
I don't know how to turn it up. I can barely hear.
Can you hear me?
I can barely. Trying to figure out how to turn it up now.
Yeah, we can hear you just fine. Please connect to audio.
Hello, good morning.
Are you on? Can you hear me?
Call the case. Let's get going.
I think he is listening. Calling case 2021-774 DP, Roy Paddington Brown versus Leandra.
Court, this matter will note the matters before the court on the plaintiff's motion for custody, parenting time, and support. Court has reviewed, again, the motion and the answer, so I don't need you simply to reiterate that. Do you have anything else, Mr. Brown?
No, sir.
Okay. Ms. King, anything else that you have in this matter?
I did go to make an appointment at Summit Point. We have to do an intake, but I don't have any insurance information for Romel for the council to be paid for.
Okay. Ms. King, are you disputing the motion that the plaintiff should have custody? The plaintiff has asked for custody. Are you disputing that?
Yes.
Oh, okay. Well, what the court does is, in this matter, if there is a dispute, the court is going to order an evidentiary hearing. The court will send the matter to the referee for an evidentiary hearing on the issues contained in the motion, meaning custody, parenting time, and support. You should get notice within a week or so when that hearing would be held with the referee, and then make sure at the referee hearing that you have all of the witnesses, exhibits, et cetera, that you have or that you need, because that's going to be the time for the hearing, and you can't come in after the fact, well, I didn't know, or, oh, I needed to present this, or I couldn't get that person there. You'll have to have everything ready at the date of that evidentiary hearing, okay?
Okay, understood.
Excuse me?
I said, okay, understood.
Okay. The court will end this matter at 10:50
Okay, calling
a.m.
case
You're free to go. Have a good day.
2023-108 DS Alexis Parrish versus Jason Weaver. Today is Monday, May 8th, 2023 at 10:54 a.m.
Court will note the appearance of Mr. Magnuson on behalf of the front of the court. The court has filed a motion to correct the uniform child support order in this matter. Mr. Magnuson.
Judge, one preliminary matter. I would note that Attorney Reed has filed an appearance on behalf of Mr. Weaver.
Oh.
Okay,
I don't know if she's in the waiting room now.
let me check.
Ms. Reed, we almost started without you. Mr. Magnuson clued us in that you're representing Mr. Weaver.
Yes.
Okay. Go ahead, Mr. Magnuson.
Thank you. I'll simply stand on what's contained in the motion. This is essentially a motion to correct the order based on a clerical error. Essentially, it's been granted in a few other occasions, and I would just ask for the same relief.
Okay, thank you. Ms. Reed, what's your position?
I spoke with Mr. Magnuson about this last week, and we have no objection to that correction.
Okay, the court will therefore grant the motion to correct. Mr. Magnuson, you can forward a corrected order in this matter pursuant to 7-day notice of entry, and we'll get that on behalf of the plaintiff.
Very good. Thank you, Your Honor.
This matter is before the court on the defendant's motion to set aside the referee recommendation. I note that as I reviewed the motion and I reviewed the referee recommended order in this matter, Ms. Broughton, it appears that your motion just reiterates what the referee's findings were, doesn't allege that the referee made any particular error. Could you enlighten me what that is?
He still has not returned my kids to me.
Okay.
And she said that day when we left the courtroom that he was to return the kids starting today, and he has not returned the kids, and every attempt I've made have been denied.
Okay, so what you're doing though is you're asking to.
So I just need somebody to enforce.
No, you're asking
the order, I guess.
Ma'am, hold on. So you're asking the court to enforce that particular order, not to set aside the referee order.
Yeah, I guess I didn't know exactly what I was putting in there, but yes, that's probably.
Okay, well, that's the issue. Is the order's in place. It's a valid order. What you're going to have to do if you want to enforce the order is file a motion seeking to enforce the order, which would hold the plaintiff in contempt and whatever other relief you want. I'm not going to tell you what that is. You need to file the appropriate motion, and the court will address that. But the enforcement of the matter is not before the court today. Okay. Do you understand that, ma'am?
Yes.
Okay.
So I have to file another motion to be brought back in front of you?
Yes. The court will deny the motion as it relates to setting aside the referee recommendation because, again, the defendant now doesn't have any dispute with the order. She just simply wants the order enforced. And, ma'am, the reason you have to file a new motion is that the plaintiff then has an opportunity to respond. I can't respond with you raising the matter verbally because the plaintiff doesn't have an opportunity or counsel doesn't have an opportunity to respond at this particular point. So he is entitled to due process notice of why he's in court. And so when you file that motion, then he'll be able to respond and we can address whatever the complaint is that you have. So
I just need him to return my kids to me.
Yep.
He's had them from me for 97 days.
Yep. And you'll have to file a motion to do that, ma'am. As I stated.
I will.
Court will end the matter at 11 a.m. You're free to go. Have a good day.
Thank you.
Court on the defendant's motion to set aside the referee recommendation. recommended order. Mr. Smith, and I look at the file, I note in reviewing all of it that you didn't appear at the motion hearing on February 8, 2023. You then didn't appear at the evidentiary hearing on March 15, 2023. What, obviously, if you were didn't appear at that point, what error, either factual or legal error, do you believe that the referee made in this matter?
Well, for starters, I haven't been getting notified by the other party of these hearings. That's why I had to provide, in the letter, I had to provide my email to the assistant of the referee to ensure that I would get these notices of these hearings.
Let me tell you what's going to happen, sir. I saw you mentioned that the referee assistant, the front of the court will only notify you of hearings that they schedule. They will not notify you of any hearings that the plaintiff might schedule. That's incumbent upon the plaintiff to make sure that there's proper service in this particular matter. So you won't get anything from the referee unless it's a referee hearing, and you only get that to your last known mailing address.
Understood. My mailing address is current. And again, I just, if the plaintiff is filing something and I'm not receiving the notice that there's an actual motion in place and that there's a hearing, I'm not going to attend because I had no knowing of it. That's why when I got the notification or of the referee's recommendation, that's when I contacted the court and I filed my paperwork to set aside the recommendation because I had no knowing of the hearing itself.
Well, what happens, sir, you have to keep your current address on file with the front of the court. You're not going to get notice if, in fact, you don't have a current address. They'll send it wherever the last known address is, which they did in this case.
Yes, well, I've had the same address for the last four years, and the only thing I received was the recommendation of the court. I didn't receive a notice from the plaintiff that there was a hearing that I needed to attend.
Okay. Ms. Sadie Jones, what's your response?
My response is he's not telling the truth. This is an excuse of his all the time. I actually went and took my motion and I placed it in his mailbox. He missed 2 hearings, and the last hearing, he was notified from the courts to make sure that he's notified. And I want to say the one before, but this is an ongoing thing with Leonard. He'll lie about not receiving anything when both of us have received it. And I would like to say that his also the response letter, I want to say he was past his 30 days, and at the last minute he decided to finally respond back to the courts because he didn't like the answer.
Okay. Anything else, sir?
I would like to add that I was not past the 30 days. The letter was mailed to me, I believe, on the 5th, and I turned the letter in well before May 5th. So yeah, that's.
Okay. Well, in this particular matter, the court does know. I don't know as it relates to the motion on the February 8, 2023, because I had not looked into that, but the court does note that the defendant did receive a notice from the front of the court as to the referee evidentiary hearing on March 15, 2023. I don't know why or what happened as it relates to that particular notice, but I just know that it was properly served. The defendant has not, other than service, has not identified any error that the referee made, either factual or legal. As a result, the court will find that the motion is unfounded. The court will deny the motion at this time, and that will conclude this matter at 11:05.